Good afternoon, ladies and gentlemen. My name is Mbongiseni Buthelezi. I'm the director of the Public Affairs Research Institute. I'm greeting you from Johannesburg, where we're based, and I'm pleased to see that there are so many people joining us from different parts of the country. It is a limitation on one hand that we have to do this virtually, but on the other hand, it's been a boon in that people from all parts of the country are able to join these events. Normally we hold them in a venue at either our offices or at the University of the Witwatersrand, to which we are attached. But with this virtual platform, we are able to reach much further. And we're able to be joined by some of our colleagues like Ryan Brunette, one of the panelists who's joining us from New York. So thank you for joining us this afternoon. My job is a simple one of really thanking the panelists, all our panelists, for joining us this afternoon, taking their time to have this discussion with us. And also for joining, to thank my colleagues who've made this event possible. So thank you, Dr. Thina, to whom I'll be handing over in a moment, as well as Vishanthi Arumugam and Dr. Florencia Belvedere, who are in the background, but we are not going to see. Just a bit of context on this event. I'm sure Thina will add more context. For the last decade, which is the period of time PARI has been in existence, we've been doing quite a lot of work of thinking about how do we improve the functioning of state institutions. A lot of that work has been working inside and in partnership with organizations of government at national, at provincial level, and at local level. And one of the things we've done recently, earlier this year, is we launched a series of papers on the improvements that we think can be made in the way in which state institutions function at a structural level. One of the papers focused particularly on recruitment practices in the public service. The public service, as we all know in South Africa, is national and provincial levels. But we are taking this work a step further in a very exciting new direction in thinking about local government and what further needs to be done to strengthen personnel regimes, recruitment practices, promotion practices, but also dismissal processes at local government level as a way of strengthening the functioning of local government, as a way of strengthening governance more generally at that level. As we all know, local government, of course, is the place at which people in the country, citizens, residents, interact with the state most readily. It's the point at which most service delivery happens. And it's a point at which people feel, I think, when there are breakdowns in governance most readily. And so that's one of the places that we need to pay particular attention to in thinking about how we can improve the functioning of our system more broadly. And I'm very thrilled that we are joined by people who do a lot of work in this area that my colleague Thina will introduce in a moment. So without any further ado, may I then, one last thing before I hand over to Thina. I'd like to request that everybody, just as one of the house rules, when you start posing questions and expressing your thoughts, to please use the question and answer box rather than using the chat function on Zoom. So please use that box. And I also would like to request that our panelists just keep an eye on the questions that are coming in. And some of them you can respond to in writing as they come in, so that, in the interest of time, we don't have to respond to all the questions verbally in one go. So with that, may I then once again thank you all for joining us and turn over to Thina and Zoe.
Thank you very much, Mbongiseni. Welcome everybody to our webinar, which is titled Professionalizing Local Government, specifically looking at recruitments and appointments. So today we have 3 panelists who will be sharing their perspectives on this topic. We have SAMWU, the South African Municipal Union, the General Secretary, Comrade, and we also have the COGTA HR Chief Director, That's Mr. Tebogo Motlashuping. And then we will have SALGA, the chairperson, the current standing chairperson, Councillor Thembi Simelane Nkadimeng. And then after that, we'll have Ryan Brunette, who's our research associate, who will be coming in at the end as a respondent. So I guess a lot of you are asking the question, why are we still dealing with this topic, 20 years later since the formation of local government, and most importantly, 11 years later after the minister, the former late minister, Sicelo Shiceka, who came into office, released a very interesting report on the state of local government, where they found that there were quite a number of problems that were happening in local government, particularly issues around state capacity that was also leading to the current situation that we're still faced with when it comes to inefficiency and effectiveness of service delivery. So these core issues lied around the nature of local government's ability to deliver services by drawing from a professional and well-capacitated bureaucracy. So, but we know that a lot of interventions happened prior that seek to really address these issues, and one of those was the actual Municipal Systems Amendment Act in 2011. But again, it laid a precursor, as we know, with the National Development, particularly Chapter 12, that looked at professionalizing and building a capable state. And it also made certain, recommendations on how to do so. But then years later, we found that SAMWU, it's great that we have SAMWU. SAMWU actually challenged the Municipal Systems Amendment Act and took it as further to the Constitutional Court. Based on the grounds that, when it comes to procedural issues and also substantive issues, they were found to be quite flawed, and then it was determined that it was invalid. And some of those issues were around passing the bill without taking into cognizance that the bill had affected the relevant provinces that the bill had to be implemented. And also, quite interestingly, they pointed out the issue around Section 56A, which actually tried to bar senior managers from holding political office, as seen as one of the issues that contributed towards the blurring of lines when it comes to applying their professional norms. So that's why we have SAMWU here, who's going to be our first speaker to tell us a little bit more about the implications of the unconstitutionality of the Municipal Amendment Bill. And most probably one of the most interesting things that we also need to ask as one of the questions is, how can we even further strengthen the Municipal Amendment Bill, since it has gone back to the Portfolio Committee of Cooperative Governance, just to try to rectify these issues and to ensure that we continue to build a capable state by complying with the necessary legislation like the Municipal Systems Act, the Finance Management Act, and also the minimum competency regulations set by National Treasury. So I'll first introduce our first speaker, which is the General Secretary of SAMWU, to give us a 15-minute presentation, deliberation on this matter. And just to give you a brief bio of the Secretary General of SAMWU, he has a very long history, which is rooted in municipal unions. And he actually worked in the local government sector for a very, very long time. He was elected as the Deputy Secretary General in the unions in the 11th Congress, and he also served in the National Education Office as a National Education Officer and Head of Organizing and Development, and also has is an International Relations Officer. And then it was only in April 2019 where he was actually elected as the as the Secretary General of SAMWU. So without wasting any more time, can I just hand over to you and to give us 15 minutes of your perspective on this topic?
Okay, thank you very much, Thina. Greetings to everyone. I just want to indicate one point that the issue at hand, we appreciate firstly, we appreciate the opportunity provided for us to share our thinking as a union on how we view how to professionalize local government and on how we can build in things going forward. I just want to make two distinctions in terms of what you find in local government. There are two sections of employment which you find in terms of the Municipal Systems Act and what you find in the Local Government Bargaining Council. There is a separate employment that you find that is in the Systems Act of Section 57 employees, which are the municipal manager, and those that report to municipal manager, which is Section 56. You then have a separate category of employees who are employed through the main collective agreement and condition of service, which you find in the Local Government Bargaining Council. That's one area. There are two areas that we're working on now, which in principle, I can tell you now, when municipalities were rearranged in 1996 there back, some was not agreeing to the separation of these employment categories because we thought we can't create an animal farm where you have a different condition of service for people in the sector and have conditions for others in the sector. But obviously, if people believe that what they raise is correct, time will tell that we are going to fail in that category of doing work. Principally, as we proceeded now, just to give as a way of background also, maybe to touch on the point that you raised about the Constitutional Court judgment that we went to go through. Those areas of the Constitutional Court judgment, firstly, it was going to, if we didn't challenge that element of this amendment, what it was going to do, it was going to firstly take away what you find in the Labor Relations Act and the Constitution of the country, where areas of collective bargaining, because it was going to give a minister powers to determine what must happen on condition of service of workers in the sector, determine what must be salary increments. It was going to give the minister powers to issue regulations to infringe on the rights that you find in the constitution of people to be able to lead wherever they have to lead in their right of association. That part we were to do it not only selfishly for members of SAMWU or to top executives in the municipality, but we felt that it's something that we had to go through with it. But over and above that background, which I know that now the department has started some work that they say they want us to go through the similar process, which we've told them that is, we're not happy with that process that they're starting. They are established procedures on how we engage, on how we deal with workers in the sector. And at this point now, the procedure in terms of how we need to find a way in which we are able to, one, ensure that there is no political interference in appointments at workplaces, so that people don't bring their friends or their relatives into the workplace, and then we end up having people who are not qualified to occupy positions. In local government, as we speak now, you can go around, for example, in Northwest, most municipalities they're on 139 section where they're under administration. And that in itself, it hampers what needs to happen in the workplace. But principally, there needs to be a discussion of if a municipality is going to put under administration, what skills was employed, whether at the CFO level municipal manager, and the directors, what are the requirements that you have at that space that requires people to be employed in that area of work? And why would you have a qualified audits or disclaimers from municipalities while we say we have proper people who when the adverts are made out, they're saying, please confirm that you know what is in the PFM, in the MFMA. Please confirm that you understand what is in the Structures Act. Please confirm that you understand the Systems Act. All of those things, everyone, when they apply, they say they understand, they know. But I think there's a lake which we must explore. It might be a painful thing to say, but if you remember previously before liberation, we had something called Town's Clerk Act, where whether councillors go out or come in, whether in the white or the black areas, the administration will be able to can function without interference. Probably what O.R. Tambo said, to say, it's not everything that the enemy is doing that is wrong. You need to pick from there. And at this point, it is time, I think, we need to consider that space and say, we need to look at how was the administration insulated properly from interference of what politicians are fighting about. It's an element that we're going to raise going forward from now on, even going to our own National Congress, which is coming soon. That part of that learning of what was there before, we need to go into. And that's elements that we need to look into to say what regulations could be put in place, what legislation that could be amended to assist that part of the work. That's one area, which one things that we need to be able to can go into and seeing how do we compare notes and say what works for us to make sure that professionals that are black in the main, went through systems of schooling and all of that, which others might be accountants, others might be proper administrators. We need to then say, how to assist them in terms of regulations and law, and also how to assist them in terms of ensuring that there is consistent updating of their skills going forward. I think that's one, those are the key levers, drivers that we need to look into and saying, yes, you're qualified, yes, you're done, yes, we do that, but then now, the water must run, and ambulance must run, nurses must work. These are run by people who must do proper planning, which we think they went to training for their own administration processes. Therefore, as we look into that space, for water to run, clinic to run, refuse to be removed, someone must plan schedule for these things. And that's how you would then insulate the interference. Because we don't, for example, you can't tell him that you need cancer for a refuse to be removed. It doesn't happen. Workers go and remove refuse irrespective. Someone has planned a weekly schedule on when to remove refuse, for example. Someone would know how to do water, light maintenance at night during the day. That doesn't require a counselor. That insulation of the administration, it's very important, but it cannot be done by a process where there must be a council meeting that approves a refuse removal schedule. No, that's a management function. That's how we need it to be professional. That's, I think at this point, I would want to pause it here for a moment. I will come back. No, I don't want to go into the process that is in the department of COGTA of them trying to do other things. That's a debate for us at a different level, or where they want to bring back the same things which Concord said they are wrong on it. I don't think, I don't want to go there now, but I think at this point, that's the brief that one wanted to say we need to find better instruments that can help us to insulate administration outside the political space. Not that you want to undermine political space. Political space is a will that determines framework on how administration must work. Thank you, Sisi Thina.
Thank you very much, Comrade Ngwane. What we will do is that we'll give the opportunity for COGTA to come in and actually share their perspectives before we get into this discussion, so that at least we'll have enough time just to think through the things that you had posed on this side. So let me hand over to COGTA, Mr. Tebogo Motlashuping. He is the Chief Director, Human Resource Management Systems in the Department of Cooperative Governance. And in that directorate, he focuses on building sound municipal institutional capabilities through development, implementation, and enforcement of an effective and efficient human resource management framework. Now, he is an admitted attorney by profession, and he also has a very interesting history as a practitioner at local government, where he was seconded to act as the municipal manager for Ventersdorp local municipality and Madibeng local municipality, respectively. And he was also a municipal manager of Lingwataimane municipality in the Northwest, and also had experience as the acting Deputy Director General at COGTA for 2 years. So we are speaking with an official who has quite enormous experience at local government level. So let's hear his position and also what the department is actually doing currently to ensure that we rectify what we need to rectify with the issue of appointments and recruitment at local government. Thanks. Over to you.
Good afternoon, colleagues. We feel very privileged as the department. We are accorded an opportunity to explain the challenges that we see in local government, and also to share with you the steps that we are taking to normalize the situation in the sector. I'm bringing the greetings from the DG of the department, who would have liked to be part and parcel of this discussion, but because of prior arrangements, she's unable to be present here. However, this area of work of the discussion that we're going to have here falls within the ambit of my work in the department. I have a presentation that is very long, but I'm not going to touch everything that is in the presentation, and I will request my colleagues just to flight the presentation so that I can take the colleagues through it. But in the meantime, they are uploading the presentation. I must indicate, colleagues, that the intention of the department in exercising the powers that are enjoined by the minister in the Constitution and several pieces of legislation, it is not intended with malice, but it is intended to see to it that we make local government as a career of choice. We move towards professionalization of local government administration, because in reality, you cannot professionalize local government itself as an arm of government. But we want to make sure that the local government administration is professionalized and it becomes a career of choice for everyone in the country. My presentation starts with the layout and it starts with the background. And I will request the colleagues just to pass through it. And as I've already indicated, that whatever that the minister does in relation to promulgation of regulations or proposing certain amendments that are to be finalized by the parliament of the country, it is intended to make sure that we professionalize local government administration, and we make sure that the minister develops minimum norms and standards, so that when a local government HR policies are implemented by municipalities, we've got standardization. When senior managers are employed in municipalities, they are employed with the standardized processes that is applicable to everyone. So that is in the Constitution. It is also in the Systems Act. It is also advocated in the white paper process. And the issue that made us to be doing all these things is because of us having identified a problem in local government. That the section itself in relation to appointment of senior managers did not prescribe the processes and prescribe the relevant skills and the expertise for the senior managers to be appointed in municipalities. Now, because of that section 72, right with section 120 of the Municipal Systems Act, then it enjoins the minister to make sure that the minister prescribes minimum norms and standards. Meaning when you appoint a senior manager in the city of Joburg, you will have the same relevant, the expectation will be that the same municipal manager or senior manager will have the requisite skill and expertise and qualification as the municipal manager or a senior manager from Umhlaba Yalingana. There is no disparity in relation to differentiation of the skills and qualification because all of them are in the space of local government. So the intention of doing it, it is not what people might say over-regulation, but it is to see to it that we standardize and we develop minimum norms and standards in the sector so that there is no commotion, there is no concoction in local government, and we have that. The next slide, these other issues that are here, colleagues, you may just read it. It's just a result of what we have identified, in relation to Brunette municipal administration. We are busy with now developing what we call prototype of organograms for all municipalities. HR practices are inconsistent. We want to normalize that. Irregular, inappropriate appointments have already indicated that we want to have that regulated. Ineffective skill development and all those other issues are the issues that are a result of challenges in local government, and if they're not attended to, then there will be unfair treatment in relation to how we look at HR matters in municipalities. And this will result in us or municipalities not being able to deliver quality service delivery to the citizenry. And I reiterate, the intention of us going through these vigorous processes is to make sure that we have this particular normality in the sector. Next slide, please. These are the interventions that we made after we have identified those challenges that are in the previous slides. We then, the minister then promulgated performance regulations. The minister then at the time also promulgated regulations on minimum competencies, so that all senior managers who are in the sector, they go through the process of competency assessment, and only competent staff members after this competency assessment will be appointed. We have developed what we call sector-specific batteries for competencies of senior managers to be appointed. We subsequently also developed regulations for participation of municipal staff during municipal elections who want to participate in local government elections. We also promulgated disciplinary regulations. We also promulgated regulations on appointment and conditions of employment of municipal managers and managers directly accountable to municipal managers. Now, this particular process, since 2011 to date, there has been normality in relation to appointing senior managers in municipalities. I am aware that there are certain quotas in local government in the sector that says the minister is not expected to promulgate the conditions of employment of senior managers in municipalities. We say that in instances where we do not have these, municipalities will have a latitude of appointing senior managers, and there is going to be disparity in relation to qualifications in terms of expertise in terms of the skill that is required for people to be appointed in municipality. That is why we deemed it fit that the minister then regulate on the conditions of employment of senior managers. Remember that the other process resides with the bargaining council in relation to the processes thereof. So the minister only made regulations on appointment for senior managers who have the requisite minimum skills and competencies. That also is regulated by COGTA. The next slide, please, ma'am. The next slide, please. This slide, I won't go too much into it, but safe to indicate the following, which is now the crux of, go back to the previous slides, ma'am, because it is important that I touch base on this because it's part and parcel of the brief of our discussion today. But just to summarize it, in 2011, Parliament, not the department, Parliament promulgated an act, the amendment of 2011, after we proposed certain amendments. And Parliament, as we are all aware, is the one that makes law, and the President subsequently ascended to the bill that was discussed and voted into by Parliament and not COGTA. That should be spelled out clearly. COGTA does not make the principal acts. COGTA makes regulations as the minister is enjoined by the principal act to do regulations. But in 2011, this was an act of Parliament and it was then ascended by the President. Subsequently, then it gave certain processes that has to be followed in the appointments of senior managers. Then SAMWU took the matter to the High Court, and subsequently that was confirmed by the Constitutional Court. Now, I want the colleagues who are in this platform also to take into account what was the challenge by SAMWU. SAMWU challenged the 2011 amendment on two grounds. One, on the issue of constitutionality in relation to the limitation of political rights, which was a substantive matter. The second challenge was in relation to that Parliament, when they tagged that bill of 2011, they tagged it as a Section 75 instead of Section 76 of the Constitution. Now, the difference between the two sections is that the Section 75 is the one that does not involve provinces to participate in the process and vote. But Section 76 is the one that involves provinces. So SAMWU said, you're tagging, not COGTA, COGTA does not take bills. Parliament tagged the bill incorrectly. And the High Court and the Constitutional Court then found out that that bill was tagged incorrectly. The court, Constitutional Court, even the High Court, did not pronounce itself on the substantive matter that relates to the limitation of political rights. If you read that judgment correctly, the judge never said that this is the view of this court in relation to your substantive challenge. But the court said, now that we have already ruled that this was supposed to have been Section 76, there is no need for us to look into the merits of the case in relation to the substantive matter. As matter stands, there is no judgment in relation specifically to the substantive matter that was brought by SAMWU in relation to that. I need to explain that quite clearly. Next slide, please. Now, the issue that we wanted to bring forth in relation to, as I've already indicated, that we need to only look at the processes that will make the local government administration professional and make it a career of choice. And these are the issues that we dealt with in the Act, and that is an Act that the bill that we have also now proposed and introduced through Cabinet and to Parliament, what we intend to. We have introduced the bill as it was in 2011. But I'll get into the details towards the end of my presentation to explain where the position is in relation to this process and what is now being proposed. But what we wanted, firstly, was to make sure that we have municipal managers that are suitably qualified and senior managers that are suitably qualified, and we also open the pool to involve people who are not in the local government sector in terms of recruitment. We also want to look into the minister looking into the processes of assisting small and rural municipalities to attract suitably qualified personnel. We also want to allow the process of checks and balances that MECs, after municipalities have appointed senior managers in terms of the Municipal Act and its regulations, then they report to the MEC. Now this is quite important also. They report to the MEC, and the MEC will subsequently report to the minister. And here, there is a misconception by certain quarters in the sector that this presupposes that the minister or the MEC will then have to give concurrence on the appointment of senior managers. No, the municipality or council is the employer. The MEC or the minister does not pronounce on the appointment in relation to overturning the decision that has been taken by council. But what this checks and balance clause seeks to address is to look at whether municipalities have followed the correct process and whether the people who have been appointed are suitably qualified. And if they are not suitably qualified, then obviously the minister or the MEC will advise the municipality that certain step that we have taken and the process that we have taken is not in accordance with the law, and we request you to take corrective actions in making such appointments. So that is the intention of that particular clause that is also been placed in this new proposal that you have put before Parliament. We also want to make sure that there is this limitation of political rights. Section 30 of the Constitution provides for the limitation of political rights. I'm not going to waste time on this because it is also a contentious issue, but to explain the intention thereof. The intention of this was to make sure that we bring the juncture between the political interference in relation to the processes and decision-making processes in local government, because that has been the serious bone of contention in relation to the encroachment of a particular process that is not legislated to appoint, for example, a senior manager. And even when decisions are to be taken in municipalities, we are quite aware, all of us, we are aware that there are other processes outside the legislative realism that contaminates the processes of decision-making in municipalities. But we say this particular clause should only be applicable to political office. And when we say political office, we are only referring to the top six of political parties, all political parties, not a specific political party, so that there should not be someone who is a senior manager and is also the chairperson of a political party, and the mayor is not a chairperson of a political party. And when the mayor takes a decision during the day in the council meeting, the chairperson, who is the MM, will take another decision at night during the meeting of a political party. And as you all know, they will recall or whatever the term that they use in that particular instance. That was the intention of this. However, we are not married to this particular notion. There's a lot of discussion, but we have also received advice, independent opinion. We also get a certification of the bill from the Chief State Law Advisor that says our limitation of political rights in terms of Section 36 of the Constitution allows Parliament, not us, Parliament, to limit certain political rights of people, especially in this instance, because it has a less intrusion effect in relation to the political rights. There are other quarters that have proposed very strongly that this particular clause should be extended to all municipal employees because there is a problem. And examples have been given in the process in relation to that. But because I'm maybe 15 minutes, I might not be in a position to can do much. But when I respond to some of the intakes, and I will then explain further. The secretary knows quite well what I'm talking about. When you are in a lift, you are a senior manager, a municipal manager, you are in the lift in the morning, and a cleaner of a municipality, with due respect, will tell you in the lift that when you don't toe the line, we will deal with you today in a meeting of 10 o'clock. So you don't want that particular situation to prevail, and that is the intention of us putting this particular clause. I know that SAMWU is vehemently opposed to this, but we will meet and discuss this at length. But remember, the last point on this one, we do not say municipal managers or senior managers should not be politically active or belong to a political party. We don't say that. They can become political party leaders, but they should not hold the position of a chairperson, of a secretary, deputy chairperson, deputy secretary, treasurer. We are saying once they hold that, there's a problem. And that is why even the Chief State Law Advisor agreed with us that we only limit their rights to a particular extent, but their political involvement in political parties and engagement in political parties is not prohibited. That should be clearly put. And this particular limitation, it happens in other spheres of government. Those who are saying it does not, they might have to go and read the Public Service Act to see the restriction that is being given. Not only in the Public Service Act, in the police, in the army, there are limitations of political rights. And we are trying to put it there so that we can normalize and make sure that the local government administration is professionalized, and we do not have interference that destabilizes the administration in local government. Next slide, ma'am. I'm sorry that I have to dwell too much in this particular one because it's a contagious issue that is now going to Parliament. Now, all these other sections that are here are really trying to make sure that our system of local government is run professionally in relation to the appointments, the signing of the employment contract together with his performance agreement to be signed, and if not signed within a specified period, the appointment lapses. So we are forcing everyone in the sector, once you're appointed as a senior manager, you need to sign an employment contract and a performance contract with targets. If you don't sign that, that process falls off. We also bring consistency in relation to how we manage performance management in municipalities. And we also put forth regulations to assist them in the employment contract and performance contracts. We also make sure that in the regulations that we have now, which are applicable, the regulations that we have of 2014 are applicable because they were made in terms of Section 72 and Section 120 of the Act, which was not affected by the invalidity of the 2011 bill. Now, we here want to also make sure that people who have been found guilty of misconduct in another municipality should not be appointed in another municipality, but there should be a cooling period of approximately 10 years and less for them not to be appointed in another municipality. And for that purpose, the minister has what we call a database for dismissed staff. And in this database for dismissed staff, all municipalities are obliged by law to touch base with the minister before they can appoint, to check whether that person appears on our database or not. And if he appears on the database, we inform the municipality that this person was found guilty of a sexual harassment case, of sexual misconduct, of financial misconduct, of any other misconduct in another municipality, and we close shop. Those particular people will not be readmitted or reappointed in another municipality unless they have undergone a particular cooling period, which I've already indicated that there is that maximum of 10 years before they can re-enter the sector. We also have the regulations, as you are all aware, that relates to the financial misconduct by National Treasury. But the rest of these colleagues have already said much in relation to the processes that bars the employment, and I may not repeat that. Can I move to the next slide, the next 3-4 slides, so that I can conclude, because I can see that my time is running up now. The next slide, ma'am. Yes, these are the proposed amendments. I've already indicated to you that the proposed amendments that are in relation to us primarily for the minister to have minimum norms and standards. If you don't have minimum norms and standards, if you don't have competency regulations for people who are entering the sector, we'll have a situation where municipalities will have a laissez-faire and appoint senior managers and municipal managers using fragmented qualifications and skills expectation, and that creates a problem in the sector. We are in agreement, I can say here, we are in agreement with the majority of stakeholders, including our counterparts in SALGA, that the issue of minimum competency levels, it's important that we have suitably qualified personnel in municipalities. And there, this thing of appointing friends and relatives and people who have political patronage, that should not happen in a municipal space. That is the intention of us going through this particular program. And we also want to make sure that there are checks and balances. After an appointment has been made, we make sure that we look at the processes. If there is anything that is wrong and the municipality does not want to correct the mistake that they did in appointing a senior manager, the minister or the minister will be given powers to approach the court for a declaratory order so that that particular appointment should be set aside. Remember, if council does not set aside an appointment that they've made erroneously, the minister can't do that, and the only competent body that can do that is the court. That is why in our proposed amendment, we are saying the minister must be given the power to approach the court to say, I have written to them, I've told them that they've appointed a person who's not suitably qualified and they don't take heed of my advice. Then the court will then order a declaratory order. The next one, ma'am, which I think we should be nearing to the end now, it's in relation to the project I've already indicated now. I've already spoken about the prohibition of people who have been found guilty of misconduct. And the next slide, please. The next slide, please. Now, the last one. The last slide, yes, this one. Now, I have said we have now gone to Parliament, and Parliament has now discussed the systems bill with all those proposed amendments that I've shared with the colleagues now. And the issue is that the process is now has been finalized at the portfolio committee, is going to the National Assembly and subsequently to the NCOP. But prior to that particular process, Parliament has consulted extensively. COGTA, before proposing this amendment, consulted extensively. But also Parliament consulted. They had stakeholder engagement in Parliament, of which I was present also during those particular consultation, and all the issues that were raised by stakeholders were then ventilated in that particular platform. We are looking at what should happen in the process that Parliament is looking into finalizing the bill and subsequently submitted to the President to assent to it and make it law. So what happens? The process here is that the regulations that we had, the effect of this invalidity is that the act as it was promulgated in 2000, in 2004, in 2008 is applicable. So we are implementing now, all of us, SAMWU, SALGA, ourselves, and anyone in the sector, we are implementing the act as it was in 2000, 2004, and 2014, and 2008. And all those provisions are applicable and are valid. The regulations that were made in 2014, they were made in accordance with the original act. The original act that had section 72 read to section 120. But there are other sections in the regulations that were as a result of the 2011 amendments. Those has been extrapolated, and only those that are in accordance with the act as it is now are applicable, meaning that municipalities are still obliged by now to appoint in accordance with the regulations of 2040 that says only suitably qualified personnel should be appointed. That's our interpretation. We sent a circular to municipalities for implementation, and we did not want commotion, that people should say that no, the act has been declared unconstitutional in totality. That is wrong, it's misleading, and that should not be fed to local government because it brings instability, it brings people to be appointed into the sector who are not suitably qualified. And we are making a plea to all and sundry that until such time that we have this act that we have put, the bill that we have put before Parliament, that we continue appointing and we continue recruiting suitably qualified people as in accordance with the regulations that was promulgated in 2014. Thank you, colleagues, and I took a lot of time, but I think maybe it was important for us to clarify what we intend doing. And in actual fact, when you hear people saying that this sector is overregulated, when you look at the laws governing local government now, we are even under-regulated, because there are certain things that the Act or different pieces of legislation are expecting to be doing, the minister to do, and the minister in most instances have been looking into how we can regularize. That is why the minister on an annual basis will then determine salaries for senior managers, so that we cannot have municipalities negotiating salaries with senior managers, and there is that fragmentation in relation to salaries of senior managers. We are in the process now of analyzing the review, because there was an outcry in relation to us utilizing the outcome of the competency assessment as a yardstick to determine salaries for senior managers. We have gone at great length to make sure that we take up that particular notion, and we are now reviewing the regulation regime, the salary regime of senior managers in municipalities, and we are consulting. We've consulted SALGA, we are consulting all organized local government, we are consulting the private sector, and once that process is complete, and that process is part and parcel of professionalizing local government. You cannot have a municipal manager of the same size of a municipality earning differently. So that's what we are trying to bring stability and that standardization in the sector. Thanks, colleagues.
Thank you so much, Tebogo, for that extensive presentation. I just hope that you are not going to meet with the secretary in the corridors, and then in the evening you start discussing other issues.
No, we are the secretary. We'll have our own platform. We discuss some of these.
We want those issues to be discussed here.
Okay.
All right. Thanks, colleagues. Just to quickly move on.
I'm going to come back. Coming back. The main allegations made here.
Yeah, coming back to those. All right, just to quickly move on, we are now joined by SALGA. We're supposed to have Councillor Thembi, Simelane Kadimeng, but there has been a dedicated senior official, the executive, Mr. Nolutshungu, who is going to give us their perspective on the current state of issues around the municipalities in terms of what has been happening since the Act has been put in abeyance, and municipalities are still continuing to have problems with appointments and recruitments that are highly based on merit-based systems. So let us give SALGA to give us their perspective and actually what they should be done for us to finally realize this agenda of professionalizing local government. Rio, welcome, and the stage is yours, but thank you.
Am I audible?
Yes, you are.
Okay, thank you, Thina. I believe you're the moderator of the session. Good afternoon to you, the team from PARI, the attendees in this webinar, and my two colleagues that come from the two formations that we work closely with. I won't get into detail about our contradictions in those engagements, but they are nevertheless healthy contradictions. And also to apologize that the president of SALGA could not make it. Our plethora of programs that are running parallel to this important session, so she asked me to step in on her behalf. Just to start off by saying, indeed, the observation that the invalidity of the Amendment Systems Act provision has created a vacuum is indeed true. As we speak and as we grapple with the responsibilities of rectifying what was identified as being unconstitutional, noting that most of those aspects are mainly in the domain of the proper tagging of the legislation. We've been down at work with COGTA, looking at the opportunities that have been created by this invalidity to see what can be done in the systems amendment domain that can not only better improve the professionalization that we envision and that we desire for the sector, but to take a much more expansive view of what it would mean to take the baton of professionalism going forward. And the reason I'm saying that, moderator, is that professionalization of this important sector of our corporate governance system is not only going to be achieved by enacting law, it's also going to be achieved by doing other things in support of that enabling legislative and policy provisions. So just for the record, to say as SALGA, fortunately or unfortunately, we are agreed with COGTA that there is an opportunity through the amendment bill process to respond to the challenge that was the subject matter of the Constitutional Court application. And I think Tebogo has gone to some lengths to draw on from comparative practice in the public service and related environments, as well as based on the advice of the state law advisors, that there is an opportunity for us to approximate wording in the contents of the bill that will insulate us from this possible constitutional attack going forward. So on that score, we do agree, because we see, and for reasons totally different to what SAMWU put forward in their argument, because SAMWU's argument was purely on strong constitutional grounds related to freedom of association, and we respect that legal argument. But the corollary, as we see it on the ground in municipalities, is that the interface between political dynamics and administrative dynamics does have a knock-on effect on the running of municipalities. Whether you look at it through the lens of governance, improved service delivery, and just the institution running on professional basis, especially at the levels of administrations. And I think we will find a way through that review process to overcome the problem. But the bigger problem going forward, in our view, is going to be not about what arose in the constitutional judgment. It's going to be about how do we better create an institutional environment and culture. And I use the word culture, moderator, deliberately. How are we going to better create a culture that not promotes this professionalism through the statute book, but promotes it through institutional arrangements on the ground that support performance, that support ethical behavior, that even puts a premium or incentive in the performance management system, that where ethical behavior is observed, is sustained, and it contributes towards improving the municipality, there's a business case for incentivizing that kind of performance over and above established norms of performance, such as financial management, emerging with good audit outcomes, implementing the agenda of the municipality in terms of the ITP, as well as any other piece of legislation that directs the municipality in the work that it does. And I won't go into that detail. But we feel there's a bigger opportunity to visit the domain of human attitude, conduct change, such that that culture environment is also, in fact, harnessed in as far as it improves the ability of municipalities to be well-functioning machineries of delivery at the local government level, but through the experience that citizens and any kind of customer of a municipality would say through their experience of receiving service, they must say, I am dealing with an institution that's professionally run, that's responsive to our needs, whether through basic things, moderators such as receiving letters acknowledging complaints, having service standards that are set out to say, on water losses on the ground, here is our standard of responsiveness. On complaints from the public, whether they come through from governance structures or from, here are the service standards. If we start getting into the domain as to what are those institutional instruments that need us to focus on to better position institutions at a local level to be professional. There's also a people development aspect to this professionalization, and that is, what is the role that professional bodies can play in enhancing the ability of municipalities to be even more professional? And I say that through the work that professionals in municipalities do, including providing for the scope in human resource policies of municipalities, that professionalization and the conduct that and the ethos that it advocates for is promoted as part of the accord between a municipal employee, whether they are at the highest possible levels, being an MM or a direct report, and whether they are at the lowest possible levels in the hierarchy of the institution. We promote that environment. Unfortunately, we've got to make an investment in creating that professional ethos much bigger than placing all of the reliance on provisions in an act of parliament or in secondary regulation to give us the culture change and the transformation we're looking for. We are also welcome the view from COGTA that starts looking at the issue of competency assessments being a non-negotiable as a basis of appointing people. And we also say we support the fact that the legislation must create more teeth in enabling those appointments which have been made not in compliance with those provisions to be nullified. And one of the ideas we are exploring as SALGA, of course, is not part of the package of proposals that are before COGTA now, as well as the portfolio committee, is that there may be an opportunity further down to the line to create a professionally run public service styled commission to be given the responsibility of looking for the best of breed of municipal managers and senior managers in the sector, assist a municipal council to find those run candidates and insulate the players in the space of a municipal council as being the active players behind determining who the suitable candidate is, and present the outcome of a credible process with validated integrity checks and assessments being part of that process. Criminal records: has the person been fired in another municipality? Has he got a history of performance in the previous municipality? And all of that detail, together with following the procedure as laid down in law, as well as in the recruitment procedure, being the basis for which a municipal council can sit down and decide that these are the 2 or 3 best candidates that we feel we should consider for appointment, including giving discretion for that commission to operate independently, to be drawn from people who have vast experience, track records, and good conduct in the work that they've done in the public sector, and have extensive knowledge over this area, so that they are allowed the opportunity to also monitor that the decisions that are a throughput of that commission are indeed being felt at the municipal level, and they generate the required return on investment, which is better managed institutions, better financially managed with good audit outcomes, but also most importantly, all-round performance in all the key attributes of a municipality's performance. Bearing in mind, moderator, there are many of them. You also need to manage the people environment. You need to also manage the employee relations environment. And you also need to manage the environment in a local space of interacting with all manner of stakeholders who have many interests that are related to the development of that municipal space. And I think we need to start looking at what those profiles and prototypes that we're looking for, that we will look at when we look at appointing those people through those established mechanisms. Noting, perhaps this is the elephant in the room, that no matter how qualified, how knowledgeable, how experienced those people may be, they also need to have the ability to manage in an environment that's politically complex at a local level. They need to bring in those elements of emotional intelligence, and also being able to work through a political system while they themselves are professional and administrators in their own right. So to us, yes, we welcome the opportunity. To us, perhaps the letdown is that we have not gone far enough to take advantage of an opportunity that has been created by this invalidity and the rectification that we are busy looking at to close the gap that has been identified. So that would be my opening gambit, moderator.
Thank you very much, Rio, for that extensive perspective from SALGA's position. I do have a very interesting question that I would like to ask you around the performance management system, and also, you know, infusing the institutional culture around that. But let me just give our colleague, Ryan Brunette, who is a research associate of ours, and he's currently doing his PhD with the Graduate Center of City University in New York. So he's coming he's actually streaming from New York as we speak. So Ryan has contributed towards writing a position paper on the appointments and removals in the public service and municipalities. And the component of the paper now, which needs to be expanded, is on local government. And that is why we are having this conversation today, so that we can actually look at the different perspectives that are coming from the interested parties. And Ryan also does a lot of research when it comes to particularly taking an interest in understanding the ways in which public institutions are embedded and intertwined in broader social contexts. So Ryan, let me give you a moment to respond before we move to the question and answer session. And can I also encourage other folks, because I can see that there are about 2 or 3 questions that are popping up in the chat box. Can you also take those questions to the Q&A box? We'd like to encourage everybody to have a conversation at the Q&A box. Even our participants can get to see these questions, because we'll be flagging them in the next few minutes. Ryan, thanks.
Cool. Thanks, Thina. Yeah, so I guess my role is to kind of respond to everyone, which is difficult because a lot has been said. So I guess I'll just focus on 2, 3, or 4 things, and I'll try not to take too much time. You know, the first thing is that, you know, clearly South Africa currently is facing a major crisis, a major economic crisis. You know, the unemployment rate is down, the expanded definition of 40%. You know, basically look at any indicator and the situation is dire. There is simultaneously a major crisis in the state. You know, we're going to need an activist and capable state to kind of lift us out of the economic crisis, but the state isn't doing so well. You know, critical administrative and infrastructural systems in a whole range of areas like electricity, most prominently also water, sanitation, almost anywhere you look are not doing very well. In some places they're on the brink of or have collapsed. Right? You know, for instance, people have the percentage of people with reliable access to water is less than it was today. Is less today than it was in 1994. Right? So in various ways we're moving backwards. Well, one major dynamic or problem in the state is clearly the kind of political administrative interface, the relationship between politics and administration. You know, everyone's seen quite clearly, you know, stuff like the state capture crisis. A lot of that had to do with the abuse of powers of appointment, promotion, dismissal, to place political associates at key points in administrative processes, and thereby to kind of cross-cut checks and balances and extract resources from the state. And that's, you know, the state capture crisis was just a very prominent example of that. That kind of dynamic is quite common in the South African government system. So it's good to hear amongst colleagues today that there's wide agreement that people want to kind of move towards professionalizing municipal administration, insulating municipal administration from political interference, creating a kind of cleaner separation between the oversight and policy functions of politicians and the more administrative operational functions of civil servants. There's talk, I think, from all three of the participants that there needs to be checks and balances on appointment and removal processes. COGTA is focusing on kind of competency frameworks or appears to be focusing on competency frameworks as a way to kind of filter out political interference, patronage, and what have you. So I guess, you know, this leads to a kind of a series of kind of queries on my part, which is that, you know, competency frameworks don't necessarily kind of filter out patronage dynamics, in the sense that, you know, one can reach a competency standard and still be connected politically, still be appointed for the purpose of kind of cross-cutting checks and balances, moving resources out of the state and into political networks and so on. That's entirely possible within the kind of within a competency standard, right? So then the question arises, which is what mechanisms, and this is really a question for Tebogo and you know, potentially for other colleagues, is what mechanisms are being considered to prevent the kind of introduction, in particular, of political criteria, you know, to prevent the appointment of political connections and so on into administrative office. So, you know, we know in the public service, there's the Public Service Commission, which you know, doesn't have that role currently, but can take up the role, take up a role in appointment processes, kind of before the fact. So it could, you know, it could be involved in kind of shortlisting. It could set up selection committees and so on and so forth. It's a kind of a constitutionally independent body that you know, could act as a kind of check and balance on political appointments. So kind of shortlist and then send it to the politicians, and that would kind of have the effect of filtering out political connections, ability to place friends and so on across checks and balances. Rio mentioned very interestingly that SALGA is thinking about a similar mechanism at local government level. That's something that we at PARI have also been considering. It's a complicated one because the Public Service Commission doesn't currently exist, and the municipal, you know, municipalities are a separate sphere in terms of the constitution, and that arguably the Public Service Commission can't reach. And so, you know, there needs to be the creation of a new body, and how that looks is unclear. So I guess, you know, I'd also be interested in asking Rio what the thoughts are there. More broadly on this kind of matter of the Municipal Systems Amendment Act and the kind of prohibition of what could be described as a kind of dual mandate, like dual office holding, so preventing people from holding both certain political offices and administrative office. This is, you know, in various forms fairly common practice, comparatively speaking, in other countries. You know, the basic principle at stake is this kind of like principle of what you might describe as kind of state neutrality, not the best term, but in the sense that, you know, if someone's holding political office in a political party, right, and high office and so on, then, you know, questions might arise regarding whether we can expect that political office bearer, which is operating as a municipal manager or something along those lines, to serve the whole community rather than just a section of it, that section that supports the political party and so on. Right? So that's, you know, the general kind of principle at stake. You know, in that principle can be kind of taken too far, and, you know, in constitutional systems, there has been in certain places a kind of like a overbearing expansion of that principle, to the extent that, you know, public servants aren't allowed to kind of express political opinions. They can't join political associations, all that kind of stuff. United States of America is a prominent example of kind of fairly rigorous exclusion of public servants from the political sphere, and that that flies against kind of rights to political association, freedom of expression, all that kind of stuff. And the Hatch Act, which is the act that achieves that, has been kind of like whittled down over the last century, or it's not such an old piece of legislation, but those principles have been whittled down over the years, and they're generally considered to have been taken too far and so on. Most countries allow civil servants to kind of join political parties and express themselves and so on. So in some countries, someone's political affiliation as a public servant is quite common knowledge, and that can actually, places like Germany, for example, it's almost expected that the higher reaches of the civil service, in the higher reaches of the civil service, that there would be that public servants will have like some kind of political affiliation, and then when political parties kind of come into power, then they can elevate people from the kind of civil service who are aligned with them in policy terms and so on. So that can be actually quite a useful mechanism to have people's political affiliations known. Obviously, Germany doesn't quite do what South Africa does, in the sense that Germany, people are kind of like appointed at the entry level, and then they rise up through the ranks, and it's quite a rigorous process of training and examination and all that kind of stuff. So what you get at the top are highly professionalized public servants, and there's a whole range of kind of rules that constrain the kind of the use of public office to serve political interests and so on. But they don't prevent people from joining political parties and so on. What most places do is prevent public servants or civil servants from holding political office, right? So the basic idea is that it's fine to have political affiliations, but once someone's holding political office, then there emerges a kind of real risk that they will be kind of subject to pressures that are inconsistent with their administrative offices. They feel a kind of a higher sense of political responsibility to their political office, which means, for instance, more pressure to use administrative office to kind of do stuff like fight party political battles, to serve constituents and so on. There's also the higher chance, if you allow kind of cross-holding of officers, of the creation of kind of conflicting and muddled lines of command, right? And this is broadly what Tebogo was talking about, right? So, it's a basic principle of public administration, that there should be, as far as possible, clarity and unity in the line of command. So you want to avoid kind of conflicting instructions, because conflicting instructions kind of cause confusion. They create conflict. You want to avoid kind of conflicting lines of accountability and all that kind of stuff, or muddled lines of accountability, because then it becomes difficult to hold people to account ultimately. So in South Africa, for example, constitutionally, there's a kind of like line of oversight and command running from council, mayor, down to municipal manager, and people that are reporting to municipal manager and so on. But we know that through the party, it's not uncommon that say the municipal manager would also at the same time be the chairperson of, say, the regional executive committee, or even kind of people reporting to city managers and so on. It's quite common that they would have political office, and they would actually have a higher political office in the party than the mayor, than a person on council, say a member of the executive committee and so on, right? And what this means is that then we have this dynamic of the mayor can't really exercise oversight and issue kind of policy instructions and all that kind of stuff to the city manager, because the city manager sits above them in the party. And so after office hours, then the kind of city manager can then come down on the municipal the mayor, or another person, and kind of undermine whatever instructions have been made, potentially remove them from office and so on. That kind of dynamic is, in most kind of public administrations around the world would be considered untenable. That's not really an appropriate way to run a kind of modern public administration. It's a recipe for confusion, for lack of accountability, and so on. So I guess that leads to a kind of question to the GS at SAMWU, which is how does SAMWU plan on addressing that, right? So one thing is that I'm kind of sensitive to SAMWU's concerns that that this is like this piece of legislation is potentially the kind of like thin edge of a wedge that is that may lead to a kind of like slippery slope sort dynamic where there's broader and broader push to kind of exclude municipal workers from political engagement, right? And I would be personally opposed to that kind of dynamic. But simultaneously, there's this problem, which is that you can't really have a situation where it's not tenable to have a situation where a municipal manager is in a higher political position than a mayor, right? So that's like a kind of knot of issues that needs to be addressed. I'd be interested in what the response to that is. And then maybe just my last point. So you mentioned, GS, that there's some concerns around kind of collective bargaining, that the legislation was kind of encroaching on what is kind of considered more like the kind of collective bargaining labor relations space, right? And I guess I just want to understand that more. So in what ways is there that encroachment? Usually, say like the higher kind of reaches of the public administration, so like your municipal manager, people reporting directly to them, like senior management, would be kind of considered to be kind of like outside the realm of collective bargaining. There'd be the setting of conditions for the kind of higher reaches of the state would be the kind of considered the prerogative of the state. But maybe you're talking about lower down positions that that the act is encroaching on, all that kind of stuff. So I'd be interested in hearing more about that. And I think that's me for now.
Okay. Thanks, Ryan, for your insights and also your comments around the issues that were raised by the three participants. Right now, we are at the question and answer session. At least I allowed you guys to, continue the conversation without restricting you, because there aren't so many questions that have been coming in, just a few of them. But let me just some of the comments as well, and this will actually lead to a very important question that has come up. One of the comments is that there seems to be a problem in our country when it comes to the implementation. One of the commentators here is saying that we have all these laws and regulations, such as minimum competency regulations, skills and qualifications required. But the problem is implementation, and that talks to compliance issues when it comes to council, because council still has the prerogative of appointing senior managers. How are we going to ensure that there is compliance? And most probably this is one of the issues that have been raised, which I would like SALGA to comment on, because they have spoken about, up a commission, that would actually be the one that is going to ensure that there is a transparent manner in which candidates are selected, and there is sufficient compliance to ensure that these candidates for senior management positions do have the competency, the skills and the required experiences and qualifications. So maybe that thinking around that thinking, since we have a differentiated local, public service system where local government is regulated, by other pieces of legislation, how would we then go around setting up these types of commissions? Are we going to set them up in or is it going to be a commission using the Public Service Commission? And there's another question is asking, Tebogo, that has COGTA ever considered bringing back professional bodies like Institute of Town Councils of Southern Africa or the Institute of Municipal Treasurers and Accountants, to come in and ensure that there is further strengthening of compliance when it comes to conduct and skills and the qualifications of those members who are appointed in these municipalities. And another one, which I think this one is posed for SAMWU. This person is asking if whether SAMWU does understand the powers that political parties have. In other words, why would you allow senior officials to hold political office knowing that there would be conflict of interest when it comes to the blurred roles and responsibilities? And they speak about issues around bullying of other managers if they hold such positions. So let me just give you a moment to respond to those questions without any flow. You're more than welcome to go and to chip in. Yeah.
Can I come in?
Yes.
Just want to correct certain things that people are raising here, which there are matters of law and fact around what our application was in Cont. And I think it might be a bit unfair to argue a court process through this session, or a bit too long, because it might also limit you. But grounds that were canvassed by my colleagues, firstly, whether it's tagging or it's word, the end point is the following. It means all that have been submitted falls off. We can come back to substance if we want to come back to, because that's a policy making process that needs to be followed. I'm just saying law in terms of when you do an application in court, you raise the main point and then you come back later on something else. And it covers all that needs to be said one by one, which I don't think we can go there. But I want to go to this point that is raised on HR policies and also on salaries of municipal managers that is raised by SALGA. SALGA and even the SALGA did not raise it now by the COGTA. SALGA, I know it's alive to our proposal that some is saying, one, you can have a teacher who works in Shabandov, another teacher works in Polokwane. They all earn the same salary. Why is it different that you will have a municipal manager or an electrician earning differently? Which COGTA is raising, and I don't think they're aware of what they're talking about. Because in the discussions we've had with SALGA which are still side issues, but in the main now, we want to standardize what happens in the sector and be able to attract proper skills that goes into the municipalities. For an example, if we need to have an electrician in Langalibalele Dube municipality, we don't have to worry that this person will say, I'm from the city of Johannesburg, or I'm from the city of Tshwane. Then it means if I go outside the city where I am, I'm going to end different. That's the discussion we're having with SALGA. They know it is on the table, that part, which that's part of ensuring that skill is attracted, competency is attracted in line with whoever form which SALGA will bring through to us. But in the main, the point is about ensuring that if you have an electrician in a rural area and the one in the urban area, they should earn the same salary. That's the point we're making on this area of work. There is a point raised also, which I want to reflect on, which relates to the issue of policies that COGTA speaks about. COGTA is not a party to the bargaining arrangement in the sector. COGTA cannot want to, if they want to speak, they must speak through SALGA. Yes, we can meet with COGTA as a trade union ourselves, and there's issues that we want to raise. But they can't raise issues that relate to condition of service of workers which we represent without having processed them properly in proper structures of what is existing, recognized through the LRA, through Constitution. SALGA must be respected by COGTA. COGTA can run outside and raise issues with us outside SALGA, because what that is going to do is an attempt to collapse collective bargaining, what COGTA is trying to do now. And I can tell you now for your information, so that it's for free, this one. Yeah? So COGTA writes to us, which we said we're going to come back to them. We told them how to process their proposal. We said, you must come through a bargaining council. In hindsight, what we're telling them was to say, if you view yourself as an employer body, you will properly go through SALGA for SALGA to be able to can bring a proposal, or SALGA to request that they must come and present to us on a matter of HR policies of municipalities. HR policies matters are a matter for a discussion in the bargaining council. And this story of that the Constitution and the MSA allow the minister to do whatever they want to do, it is outside. In fact, we can challenge it. In fact, it's outside what is established on condition of service in the LRA. Probably previous leadership did not challenge it, but what they're trying to do, it's outside those prescripts. We can argue about it in law next time, but they can want to create human resource policies without SALGA being part of that process. They must come through SALGA to talk to us, and when we must talk to them, we'll talk to them on intervention basis of what we find in law, which we know is correct. But they can't just come and say, we must serve in some committee that is going to deal with the HR policies, implement arrangement. In fact, that attempt, I will tell you now, the attempt they are doing now is to reverse a Constitutional Court judgment that SAMWU challenged. And to say this has existed at the time of the establishment of the Systems Act, it's something that can be tested in law differently, which we don't agree with. In fact, for the information of everyone, the formation of the Structures Act in local government and the Systems Act, they were championed by some and were under no illusion or not at the time. If there is an interpretation, if there's interpretation contest, that can be argued somewhere else. But COGTA can come here and say to us, no, this is established in law. This is, there's not, if we must argue that point, let's go somewhere else. It can't be argued in this form. And if part of what they're doing now in submissions of some policies and steering committees that they want to bring through, they want to do it, it's going to be a battle whether in law or whether they want to prefer a discussion. They must choose which space they're going to. Because the white paper on local government, it was not out of a COGTA discussion. It was SAMWU who argued for that moment, for that to exist. Rio can speak if he still remembers that part. But we can't have a situation where Jack rolled here by people who think that now they have something that they have in the hand. They think we don't know the history of where this thing started. COGTA sit back when the municipal workers are not paid their salaries. I speak to SALGA daily. Rio, I phone Rio when salaries of workers are not paid. And Rio will say, no, okay, I'll speak to the rest also. And I'll fight with him also, Rio, at the same time. I'll fight with the minister. But they can't come now and want to behave as if the requirement for employment is their prerogative in municipalities. That point, it's a point that's still to be argued when we meet properly, because COGTA, sit back, national COGTA, sit back when pension funds are not paid to workers. They sit back when medical aid money is not paid to workers. They want to come now and they say they have some mechanism of employing people. That proposal they're bringing through, it is not for them. They should be able to say, in law or regulation, can we discuss how this could be made? They can't just come and say they have a mechanism that they've developed out of, I don't know from where, whether the current person we're talking to now has been a municipal manager, has been one. It doesn't replace the fact that a department of government keeps quiet, no one do anything.
Comrade Koena? We get the point clearly, because I also want to give an opportunity for COGTA at SALGA to respond. But what?
The last one.
Just 1 minute. Just 1 minute.
The last one. The attempt from COGTA is to try to collapse collective bargaining so that workers are unable to bargain for themselves, because the HR policy issue that is raised from COGTA and regulations in themselves, they're going to collapse the bargaining council, which is the point we're not going to allow and agree to. I'll leave other points for next time. But for that point for now, that's where we are. They must stop their tendency of trying to collapse collective bargaining that is established in law, in LRA, in the Constitution. Therefore, we can't give one person called a minister to determine our salaries of our members and benefits of our members. Thank you.
All right. Okay. Thank you. Thank you very much, Comrade Koena. In fact, you are raising a very interesting issue around issues of organograms in municipalities, because those are very contentious issues. And it's quite interesting that Tebogo is raising the fact that they want to standardize organograms, and also taking into account that the bargaining council needs to be involved in those matters. So that's another discussion that I would definitely like to have with the both of you at another time, because it's very extensive. But let's just have Rio. Rio, can you also respond before we go to Tebogo?
I just want to say,
and Rio, and Ria would also like to just touch a little bit about the issue of performance management systems in municipalities, and how this can be inculcated into an institutional culture, because that is something that we are having serious problems with in our public service in general. Yeah.
Okay, thank you, Thina. I just want to say you are right in your view that the discussion of the potential role and the makeup of that role, that collective bargaining arrangements and systems as internal institutional arrangements within a municipality, as well as sector-specific arrangements, what role, if any, can they play in the agenda of professionalizing local government? And the answer would be they have a big role to play. But it's just that the context of collective bargaining also has its legal machinery, which is not situated within the Systems Act provision. So you are right that that discussion probably needs its own day and its own webinar on a particular day. Because if we get into it, Koena will turn me into a negotiator in this webinar, and I didn't come here to do that. I'm resisting that temptation. On the issues you've raised, just to maybe reinforce what I've said earlier on without repeating it. The point we are making is that, and probably let me use the analogy of quadrants. In these quadrants of professionalization, there's a role to be played by norms and standards, and possibly legislation, which legislation can take care of in making sure those uniform standards are not up for discretion, that are implemented, and the very strict mechanism of monitoring them. But there's also a quadrant that must focus on leadership and management. There's a lot that needs just good basic leadership and management to resolve. And that role should not be crying out loud for legislation to be enacted, because those leaders and managers have got adequate resources in terms of enabling legislation and authority to lead appropriately. And when they impact through their leadership role in a manner that promotes this professionalism, the organizations are going to start switch incrementally as part of embracing that professionalism. So we must never make the mistake of thinking all of this is to be resolved by legislation. Then there's probably a quadrant of things that are transformational in nature, things that we have been scared to talk about, but we must start thinking about, because we are almost at the 25-year period of local government come December this year. And we know the things that have not worked, and we know the things that need an institutional rethink. For example, if we take the view that municipal councils have an oversight role, have a policy-making role, and let me also say they have a legislative role because they are in that instrument in a local sphere. There's a greater opportunity for them to play a meaningful role in the attraction and retention space of key skills without necessarily being the operational drivers of those processes. That's really what we are talking about when we raise on the table for possible investigation, because we need this to be backed up by research, by evidence-based discovery. And one of the things that we have at the back of our minds as SALGA is that there may be two ways of doing it without breaking the band. Breaking the band means changing the constitution. We can create we can look at the opportunity of creating a much more comprehensive suite of regulations that avoid looking at the area of regulation as just being the recruitment process, as just being the recruitment of senior managers, subjecting them to competency assessment, and then appointing them to council. We could expand the envelope of coverage of those resolutions, of those regulations. And then they will start setting out the institutional parameters of doing that process in a well-governed, transparent. And when I say transparent, we can even take the view that we want to style the appointment of senior managers, MMs and direct reports, like we do when we appoint a public protector. We subject that process to public scrutiny, bring the confidence of the public back in the system, make sure that the people that are vested with that process have got integrity, have got skills, are to be trusted, they have a track record, but they will be doing that as a service to the country, as opposed to a service that is commercially influenced or has considerations that have to do with other interests, totally unrelated to the agenda of transformation. So we could do that through the window of the prerogatives and the authority that the minister has. And I'm in disagreement with due respect to my colleague on the negotiating table that the minister doesn't have a role. The minister does have a role to create instruments of regulation where those are merited and when those advance the goal of a developmental local government system. Where we tend to be uncomfortable with the minister's appetite for regulation is when they want to over-regulate the municipal space to a point that every determination of judgment and discretion at the level of a municipality is to be found in a provision of regulation. How many people must be a panel? Must the panel be constituted by Koena or must it be constituted by my cycling? We don't want that. We want the exercise of that discretion to be done at the right place. And if the right place is through the instrument that we advocate for, at least we can talk about the modalities. If that option is not attractive or not feasible for whatever reason, whether there's a pushback on it or it hasn't found traction or is not based on some empirical evidence, maybe the opportunity presented by the Public Administration Management Act, which is an incremental expression of government's intention to create a government at the level of DPSA, they call it a single public service. Just so that I qualify it, moderator, we call it an integrated public service. And the reason why we want to call it an integrated public service is because we want a corporate governance system that does not lose its constitutional foundation and instruments. That local government becomes a sphere and is not a tier of government that is directed by circulars or memos what to do. So if the Public Administration Management can create a window of creating that opportunity, then we can create a much bigger commission which will have the responsibility of looking at this focus across the different spheres of government. Obviously, that will take a lot in way of mobilization of consensus, in the way of ensuring that the local government family is taken on board in that discussion, but in such a way, we do not end up with more problems that we have in local government, which is we have a financially constrained environment. We've got a lot of unfunded mandates that are coming up every now and then with every piece of legislation that comes through the statute books. We'll have to look at those implemented modalities. But the idea of insulating the policymakers from the rams and the nuts and bolts of actual running the appointment process, in our view, will go a long way towards freeing them in making the best of the decisions that are expected from as policymakers and people that exercise oversight. So we will look at it from that domain in terms of what kind of policy reform or legislative process or avenue can give rise to realizing that view on the back of what I would call a very open and comprehensive public consultation process and mobilization, because you can't take people on board when you are rushing these instruments of reform. You said to me, I must speak about PMS. I don't know. There's so many things to talk about PMS, because PMS in local government is uniquely positioned, unlike in other environments or jurisdictions like the private sector. Legislated as it may be, but what the legislation has done, it has legislated institutional performance. When you look at the value chain, you look at the IPP, you look at quarterly reporting, you could look at how all of that turns up being the contracts of MM and the review process. We've legislated that. But we've decided that a big part of what is a contribution to the performance of a municipality is out of the loop of that regulation, which is how much time are municipal employees spending their time on productive outputs that help the municipality deliver services. How much of the time are municipal employees spending on ensuring that they prevent wrongdoing of any nature in a municipality? How much time are we spending on ensuring that they have an accord with their employers individually in taking anti-corruptive stances, as opposed to be captured in the terrain of corruption, or finding themselves being enrolled in that process for whatever reasons they may do in their individual capacities. But what we've done, we've left a large group of people in our performance management system. On record, we have about 263,000 employees in the sector. Out of those, the ones that belong at a level of senior manager and direct account for less than 1,500 employees. We designed in law a performance management system that is going to hold this small group responsible. I'm not saying that's wrong, but I don't think it's enough, and leave the rest of the workforce, which is so integral. It's a pipeline, it's an assembly line to this performance, and we decide to leave it out of the coverage of that legislation. So the intent of the legislation, in our view, is right. There's nothing wrong about it, but we feel it doesn't go enough in holding everyone accountable end to end in the municipal system for all elements that are required for that accountability, from ethics, disclosure, transparency, performance, as anything that you can conceive of, you write on a checklist that a municipal employee ought to be doing, a councillor ought to be doing, to make sure that these institutions of ours are run very well, are governed very well, are productive machineries, but they are also responsive to the needs of the people. And most importantly, they are also accountable and transparent in the manner in which they do their work. So those are the kind of views we have, moderator, at a conceptual level.
Okay,
Thank
all
you so
right.
much.
Thank you very much, Rio. In fact, it even probes us to even go further and say, to what extent are we able to link, output-based performance of municipalities to actual outcome-based performance of municipalities. So maybe that's another aspect that we need to start considering when it comes to evaluating and assessing the performance of senior managers who are given the responsibility of ensuring that services are delivered to those communities and they safeguard municipalities when it comes to its governance implementation. So let me just quickly give Tebogo, because Tebogo has to leave in the next 5 minutes. So let me just give him a moment to respond to some of the issues that were raised. And with Tebogo as well, I would actually even issues of taking into consideration middle managers and lower skilled or unskilled employees of municipalities, because one of the issues that we also need to start thinking about is how those employees contribute towards the performance of an institution. And if some of the employees do not have the requisite skills, but have been in the municipality for a very long time, and they demand to be absorbed, do we take into consideration, the recognition of prior learning that needs to be thought of, that we know that Deep SA thinks about such things. So yeah, just a quick one.
Thank you, Program Director. I think, may I indicate that my presentation and the issues that I've raised were based on the request that was made to the DG in relation to the content of the discussion today. So it was solely meant along those lines. The invitation that was given to us to come and talk about professionalization in local government and the appointment of staff in municipalities. And the presentation was based on that. I have said in my prelude that all what we intend doing is not intended with malice, but to look at how we then respond to the challenges that we have identified as government. And I reiterate that the minister is enjoined by law as matter stands unless the law is changed. Section 72, read with Section 70, Section 120 gives the minister certain powers, and the minister has done this over years in relation to the response of the responsibility and the powers given to her by law. The Constitution gives the minister certain powers. The minister, when we look at Section 154 of the Constitution, that indicates to the national and provincial arm of government to give support to municipalities, and it gives specific indication as to the executive in cabinet who is responsible for that particular function. And in my opinion, in our opinion, it has been done over years since the advent of democratic local government. The minister has been doing that in accordance with that, and that is not going to change today on the basis that the minister might not have certain powers. And I'm not going to respond specifically to some of the issues that have been raised, but safe to indicate that I don't think that we as a department, we might be so mischievous, for lack of a better word, or disingenuous for us to even try to trample into the collective bargaining processes. It is not the intention thereof. That is why in whatever thing that we do that relates to HR matters in municipalities, we consult. All stakeholders are consulted. And the discussion will then emanate from those discussions if indeed we are within what the law empowers the minister to be doing or not. And we are in the process of engaging our counterparts. We sent official letters to SAMWU, LG SITA, and IMATU, and SALGA in particular in this particular instance in relation to the issue of HR policies. And the discussion that the secretary is bringing forward on the table, he's quite aware that they are to be discussed in a bilateral meeting that we are proposing, that we meet and we discuss this. So in a nutshell, I'm just trying to say that those issues that is raised, okay, we hear what the SG says, but we say we will have a discussion that we're going to have in relation to that. But there is no intention for us to trample into the collective bargaining because we are aware of what is happening in that particular space. And there is constant engagement that we have with SALGA in relation to what the approach might be. And there has been some differences in the past, including SAMWU, but those are not insurmountable differences that we had in the past. And this might not create a problem. The only intention, all of us that I think we all agree, is that we must professionalize local government administration. The modalities thereof, like you has indicated, should be discussed on how and the parameters that give us the power to do certain things within the parameters of the law. And that's exactly what we're trying to do. But going to specifics in relation to what has been raised. One, this competency assessment that we have, that also our counterparts SALGA are also running before municipalities can appoint senior managers. We've got a forum and a unit in COGTA and provincial departments that include also SALGA. That means on a quarterly basis and review the appointments. So there is no way that the implementation part might be lost. From 2011 up to date, we have made sure that we have tracked the employment process of senior managers from the advert up to a stage where municipalities then decide or approve the recommendation by the panel. And we have gone through the process, and I have enough time I could tell you that we have written letters to municipalities where we made appointments of incompetent people, and the MEC and the minister have gone to court, and there are cases where we said, but your appointments are not in accordance with the law, and this must be reversed. The recent one is the one that has happened in Western Cape. So what I'm saying, for purposes, for purposes of us implementing this, we've got a dedicated unit in COGTA that looks to it, and all senior managers, once they have been shortlisted, they are obliged to undergo, once they've been recommended, they are obliged to undergo a competency assessment. We've got a database of all competency results. Remember that all these people that are doing the competency test for senior managers are appointed by COGTA. So all the reports, we have them, and we make sure that municipalities, when they appoint, we advise them based on the outcome of the competency assessment. So the implementation over years since 2011 to date has not been a problem because we've been following this particular process. And I think even after this new act, this bill is made into law, we will continue to monitor like we are doing now. We make sure also that in the form that we have, the form, the template for all senior managers and in municipalities, we put explicitly in that form, application form, are you holding a political office? If a person answers yes or no, and then at the end, it is clearly indicated that any wrong information given to us on the basis of what you said of holding of political office, the whole, your application then becomes null and void because you gave us wrong information. That an extract that we got from your public service and all that. So we follow that. We follow an implementation process. I can tell you now that over years until to date, and until upon the uncertainty in relation to the implementation of 2011 amendments, we can indicate to you that there has been no one who has been appointed in senior position who holds political office as defined in the regulations and the act. So that's the issue that we are trying to maybe to answer Rian, to say that there are mechanisms in place that makes us to check if this particular thing has been followed through, and we do that. That is why we were saying that we have had a meeting with SALGA, and we've agreed that this invalidity of 2011 Act creates a very serious problem because people interpret things incorrectly, and that is why we send a circular to municipalities to guide them on what should happen. And we are engaging with the SALGA so that we can also, in the process of us, one proposal on the table is that we should have some sort of a framework or a guideline that will form the basis of assisting municipalities when they appoint, so that we should not lose track of the fact that we want suitably qualified personnel in municipalities. The professional bodies, we are in discussion with professional bodies. We have met with a number of them because they've got a direct bearing in the quality of people that we want to appoint. But when we spoke to colleagues in the sector, there's been several proposals. There was a proposal of a body called SAMWU, the Institute of Accounting Officers, where they also wanted to introduce a private bill to Parliament in order to professionalize people who are coming to the sector, especially senior managers. When I speak about appointment of staff in municipalities, please, at the back of our mind, we are referring to senior managers. Senior managers, in definition, is the municipal manager, and all managers are accountable to senior managers. We are not getting to bargaining council processes and all that. Now, what we said, let senior managers indicate to us the shape and form of the professional body that they want to have in local government. There are proposals that have been made for any other person who wants to go to the sector to write a particular professional examination, which also has sector-specific guidelines, so that when they then become members of that particular professional body, then they can be eligible to be appointed as senior managers in municipalities. That's very progressive. And we are saying that whatever advice that comes into being, it will find us having already the basis. We've got the competency regulations. We've got the regulations that deals with the skill and the qualifications that is there. So that will be the basis that can get into that formal structure that will also be promoting ethical conduct of senior managers who then belong to that proposed professional body. And we support that, because we are saying that when you look at all professional bodies in the country, doctors, nurses, chartered accountants, and all that, they have professional bodies where they can even be, because of unethical behavior, be dealt with not through the disciplinary process in municipalities, but through that particular professional body. And we say that we are amenable to such an idea. We will engage and see to it that we have a professional body specifically for local government. Now,
right.
the last point.
Tebogo, I know that you also need to jump off for a meeting at 4 p.m. So I'll just give you 1 minute to wrap up so that you also don't become late. Yeah.
1 minute I'm going to utilize to say that we've got a healthy relationship with SAMWU, and the political head of COGTA has got an alliance with COSATU that means also an alliance with SAMWU. So the differences that we have might not create such a problem that we cannot greet each other. We will meet, discuss this, iron them out, and Secretary, you must respond to our letter where we are inviting you to a meeting so that we can iron out all these differences. And thanks for giving us an opportunity to be part and parcel of this webinar. Thanks.
Thank you very much. Thank you very much. Panelists, we have now gotten to the end of our program today. In fact, we are just about 7 minutes over. Let me really thank you very much for coming through to participate in this debate. Now it is actually becoming much more clearer that there are other issues that we need to also filter into this discussion, particularly around, issues of the bargaining council, because some of those issues even speak to, professionalizing administration in totality, not just senior managers, but also staff members who are actually the engine. I always say that operational staff are actually the engine because if that engine doesn't function, then having this debate, and it was actually a great platform. It has improved my understanding and provided more clarity around certain local government matters. So indeed, this webinar has been very informative for, informative for most people. So just to wrap up, I don't know whether my director would also like to say a special thanks before we close off. Mbongiseni, is there anything that you would like to say before we close off?
Just to say thank you very much for everybody and for bearing with us for going a little over our time limit. Indeed, as Thina has said, there's a lot. This was a rich discussion that I think has opened up a whole number of areas. Rio, you mentioned, for example, that there's a lot of work that still needs to be done in terms of research that can then bring the evidence that decisions can be based on. So indeed, and I'm pleased to say we're meeting with SALGA actually tomorrow and our MOU to think about areas of research that we'll collaborate on going forward. So these are all things that we're going to take forward together. In the proposals that I suggested we're going to be working on going forward, we're also going to be reaching out to you for consultation, for your thinking on some of these things that it might be practical. The last thing I want to say is the key thing is somebody has mentioned in the comments that we're wrong to say that we're in a crisis. Of course, we're not in a crisis, but the situation is dire. Perhaps that might be the case, but there is growing public dissatisfaction with the state of things in local government. And the sooner we get around to reaching consensus and to fixing the problems of professionalization, of improving service delivery, the better for all of us before this leads to instability that we cannot control. So I think there's an urgency here that we all need to be alert to, and I'm sure we all are, but we need to move with speed to get to the point where we fix all these things that you've all so accurately named. And with that, may I say once again, thank you everybody. Thank you to all the participants. We look forward to continuing the discussion.
Thank you.
Thank you. Just 1 point for you. Just two before everyone leaves.
Comrade Koena, hey, you're towing in our time.
No, it's just two things. I'll tell you why I'm raising these two. I won't elaborate on them. Ne?
Okay, all right.
When you do whatever you do in terms of research, ne? What is the role of IDP and manifesto of organizations in terms of service delivery? Because one doesn't exist in between of the other. That's one area I wanted to raise with you. The second one, which is the last one, is about if we say local government is in the core phase of service delivery, why is it receiving 10% or less than 10% from the national fiscus? Those two issues, look into them, and I can tell you now, people are not telling us the truth. Something is not happening properly there. That's what I wanted to raise. So that if you are doing research work on your side, those two elements I'm raising now, that's one, needs to be looked into so that we don't speak wrongly to our people. Thank you.
No, if I can answer the last one briefly as well. We have actually looked at the last one. And we've written
there you go ahead,
local government fiscal framework, which is in accord with what you're saying. Local government is being changed. And this is going to the Budget Council, actually. We have a meeting with SALGA on Thursday to present, to help them craft what they're going to present at the Budget Council on precisely this issue.
That's central to us as some. That's very
and I'll definitely forward that report to you, Comrade. Yeah. Great. Okay, thanks everyone.
Thank you. Thank you.
Bye.
Thank you.
Thanks everyone.
Thanks, Ryan.